now we're not always sure what solicitation is. So what is it, what is it not, or what are the exceptions? So we know that there are three primary exceptions to what would be considered improper solicitation. It is extremely, extremely rare, almost never, that a consumer files a complaint dealing with a lawyer's advertising, right? It almost never comes into play. So when does it come into play? You have the state bar disciplinary arm, which again, was what I was talking about, and I put in there proactive because as I just talked about, with certain states that care and certain states that don't, there are certain states that are very proactive in the way they look at a lawyer's advertising and monitor it and do send you letters from time to time. And so that's one aspect. Responding to an attorney complaint, that's probably the one of the most used, which is, a competitor complaining about the way that you're marketing or advertising. So responding to an online review, this is an area where lawyers continually get into trouble. You have to be very careful about violating 1.6 and making sure that if you're responding to a negative review or problematic review, that you are not revealing confidential information.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Micah Bookdahl. Micah U. Bookdahl is an attorney focused on assisting law firms with business development initiatives. He is the past chair of the American Bar Association's Standing Committee on Continuing Legal Education and a past chair of the ABA's Law Practice Division. Based in Morristown, New Jersey, he is president of HTM Lawyers Incorporated, a law marketing consultancy. Micah is a member of the Association of Professional Responsibility Lawyers, APRL. The webinar presentation that you're about to watch will be approximately 1 hour, and Micah will be taking questions from the audience towards the end of the presentation, time permitting. So if you have any questions that you'd like to submit, you can do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Micah to discuss You Can't Do That, ethics issues and concerns in legal marketing and solicitation.
All right. Thanks, Nina. So you can't do that. That comes from a college basketball game where the students chant, "You can't do that," when there's a violation on the court. So that's as opposed to a court of law or a court of public opinion. Let me point out that any of the screen captures that I use today or the examples that I give don't necessarily suggest that any of these law firms or any of these businesses are unethical. I use them as images that portend to the subject matter that we're discussing. So I always start with the original Bates v. Arizona ad from 1977. This was the ad that they wanted to run, that Bates and Van Oosteen wanted to run in 77 when lawyer advertising, lawyer marketing was prohibited across the board. As you know, or as you see, that those ads were created, or those those were things that law firms wanted to do in regards to directory advertising back then. If you were a plaintiff's firm, your main advertising vehicle was probably your Yellow Pages ad. If you were a big law, your main advertising vehicle may have been your six-figure Martindale Hubble listings. It might have been billboards that you ran in your market. Today, I'd say about 95% of the campaigns that I look at each day are related to digital marketing. Almost everything that I look at every day is digital, is technology driven. And many of the issues that come up really relate to the use of digital advertising and digital marketing. I always remind people that whether you find an ad in good taste or in bad taste is not part of the evaluation of whether something is an RPC violation. A prominent personal injury lawyer in New York sent this to me. He was appalled by it. He's like, this is literally an ad on an ambulance. But of course, he's not ambulance chasing. He's on the ambulance. And so, I remind people, in New York, if there's an accident, yet there's that 30-day no solicitation window that you kind of avoid if you happen to write this down as they're wheeling you into the back of an ambulance. But it's always interesting to see the sort of entrepreneurial approaches that various lawyers take in the way that they market themselves. So what are we going to talk about in this hour? So all the ethical considerations that come into play as it relates to marketing. So it used to be that most of the program would be around the first thing listed here, advertising restrictions, which we will talk about. But there are other aspects that come into play when we talk about lawyer marketing and lawyer advertising. There's making sure that we don't inadvertently create an attorney-client relationship that we don't want. Because the internet makes it very easy to market yourself in all kinds of practice areas, there's sometimes the issues of competence, whether or not you're presenting yourself in an area that you really know how to practice in. The concept of confidentiality, which we'll talk about as it relates to various aspects of digital marketing tools, making sure that there's conflict checks when you're soliciting and when you're bringing in new clients via some of these advertising and marketing tools. But a lot of the things that come up in real life today, as I always say, are issues as they relate to unauthorized practice of law, UPL. Related to that is multi-state jurisdictional issues and practices, issues of solicitation, and various issues of fee sharing, which we'll talk about. So, and it's a whole new world of ethical considerations for me when I'm looking at marketing, advertising, solicitation issues. One of the things that keeps this practice area so interesting for me, even after teaching it for 25 years, is that it's constantly changing. And there are new issues that come about. And so, we live in a world where there are issues as they relate to management service organizations. If you don't know what MSOs are, alternative business structures, litigation funders, and the way that they try to sometimes influence some of our advertising, private equity investors. You may have read of McDermott looking at private equity investment in Arizona at the big law level. Access to justice, which is really, provide sometimes many states allowing non-lawyers to provide legal services, which creates competition for some of us, which then creates issues because they're not lawyers, they don't necessarily have to abide by the same rules that we do. And then there are issues of fee sharing with non-lawyer staff, for example. So in the fee sharing area, there are a number of states that have looked at what you can and can't do, for example, with your marketing team. In Arizona, ethics opinion says that you can pay a marketing director incentive comp, but it can't be based on a percentage of increased revenues. But again, it can't be based on a particular matter. Utah has an ethics opinion that looks at it, as do New York and Tennessee and Texas. So things to keep in mind. The other thing to look at in terms of fee sharing deals with, both not only litigation funders, but when you're fee sharing where one state might have an ABS. For example, Arizona might have an ABS, but the state that you're in doesn't. And so there are issues that come about in terms of referrals and litigation funding and what states you're in. Same thing with DC, which allows fee sharing with non-lawyers. If you're a lawyer in Texas and there's a fee sharing issue with a law firm in DC, which one takes precedence? And so there are various things that kind of cloud some of the fee sharing issues that we'll talk about. And then today, like influencers, influencers are becoming a huge part of marketing and advertising, and lawyers are starting to just dip their toe into it. But what an influencer says or does or talks about in a TikTok or in any kind of messaging, it brings up other types of issues that you have to concern yourself with. So the AVA model rules, these are the areas that, I don't spend a lot of time on. Everybody kind of knows them. These are sort of the givens in lawyer advertising 7.1, which deals with not making false or misleading statements, being truthful and not deceptive. I always remind people that just because a tagline or a commercial or an ad is completely truthful doesn't mean that it couldn't be considered misleading or deceptive by nature. 7.2 deals with the specifics regarding advertising and communication. 7.3, soliciting clients. 5.5 deals with UPL. Every state looks at these rules and interprets them a little bit differently. And so, that's where I make my money, right? Like, because if they were consistent across the board, it would be very easy to abide by them, but they're not. And so every state's a little different in terms of the way they both interpret the model rules and the way that they've made slight changes or additions to their comments. But most of us know, we know these model rules. We know those sort of core components of advertising in regard to, whether you need to have attorney advertising on an ad or on a website, whether or not you have to have certain disclaimer language in certain states. Those are all kind of the basics. And I kind of expect by now that most of us know what those basics are. It's really other areas that come into play that create sort of levels of confusion and things where you might get in trouble for things that you hadn't really thought about. So in terms of solicitation, for the first, probably 15, 20 years that I taught this course, I never talked about solicitation very, very much because it was always sort of a given. Like, we know what solicitation is, right? But now we're not always sure what solicitation is. So what is it, what is it not, or what are the exceptions? So we know that there are three primary exceptions to what would be considered improper solicitation, right? One is that if it's a family member or a friend, okay, that's not an improper solicitation. If they're a current or a past client, and that has come into play a great deal in areas such as class action, where a lot of times in your retainer agreement or in your agreements with new members of a class, you'll say, like, you're now a client of our firm, and we might contact you from time to time with other opportunities, and so that becomes a little bit of an end around for opportunities to solicit folks in that space. But there's the current or past clients, and then another lawyer, right? Those are sort of the three exceptions to the rule. But every state's a little bit different in the way that they interpret aspects of solicitation and in the way that they interpret the way an ad might be targeted. So, for example, in California, this is from last month. California Governor Gavin Newsom has signed a bill into law that blocks Golden State lawyers and firms from sharing contingency fees with out-of-state firms owned by non-lawyers. So that goes back to that concept of fee sharing. So you have that California ban. There's also in Missouri, there's some specificity around the way that you could solicit someone through mail. Like, you could send them a letter through regular U.S. postage mail, first class mail, but you could not send them a letter via priority mail. So there are all these various nuances and ambiguities in regards to solicitation. And you have to be very careful about making sure that you don't violate them, and understanding the difference between real-time solicitation and not considered in real time. So targeted social media advertising, these are examples of, obviously they're not examples of any ads that I've worked on or any of my law firms, because I wouldn't use them. But these are examples of, the types of ads that, that I'm often reviewing on a daily basis regarding, sort of various aspects of targeted social media. And so we always want to be careful about not having ads be considered targeted by certain states like New York and Florida, which look at whether or not you're targeting a specific audience as opposed to targeting sort of a wide-ranging audience. But when you're creating these sort of social social media ads. You have to be very careful about things like whether or not you're properly licensed in the states that you're marketing. So these examples, none of these really relate directly to a particular location, but say it's an ad that's very specific to something occurring in Chicago. Okay, so are you licensed to practice law in Chicago? Okay, in Illinois? Do you have co-counsel there? Do you list that co-counsel in your advertising? Are you in a state that requires pre-approval of ads, which are often extremely problematic when you're dealing with things like class actions where time is of the essence and you really don't want to go through that ad submission process. So that comes into play. There are IP issues that we're going to talk about in a minute. You see there, I don't typically let my law firms use trademarked or copyrighted taglines or logos or images in their advertising of the company that's often the defendant in a matter. As you see here, some folks do. So everybody's a little bit different, but I've seen companies kind of push back or fight back in terms of, someone utilizing their IP in ads without approval. And whether or not you have the proper disclaimers and privacy policies kind of linked into these ads when you list them. So these are all sort of, what I call headlines. These are all relatively recent articles. Most of these are from Law 360, which I kind of peruse every day. And so the first one, judge disqualifies law firm over false press releases. And so in this case, I think I read this last week. California federal judge disqualified the firm from serving as lead counsel in a proposed class action after finding that the firm issued press releases to attract clients with headlines stating that it had filed certain suits when in fact it hadn't actually filed those claims. And so the reason I use this example is really as it relates to the concept of press releases and our press releases advertising. And so in this case, this was a press release that clearly was considered advertising to solicit clients by the California federal judge. Press releases may or may not be advertising and may or may not fall under advertising restrictions. So when do they fall under advertising? If I take a press release and I email it directly to a journalist, okay, that press release is not advertising. I can use puffery. I can say whatever I want to say. I can use any terminology I want to use. That's a direct email from me to the journalist. Now, when I take that exact same press release and I put it up on the web, now it often becomes advertising, and now it falls sort of under that scope. Now, is that advertising in that I have to have it approved by anyone? Not likely. But in some states, for example, in Florida, let's say if you know that a press release is going to then be taken and put up verbatim on a site, sort of cut and pasted, then it didn't go through editorial oversight. And so that kind of changes the scope of the press release. I just did a press release literally last night that was posted on PR Newswire of a matter dealing with active litigation. PR Newswire has very strict rules in regard to posting press releases with active litigation and all these hoops that I have to jump through. Now, those aren't hoops that I have to jump through for ethical considerations as a lawyer. They're hoops that I have to jump through for them to put up that press release. But there are things that make press releases sometimes marketing, sometimes not, and you want to be careful about the way that you use those. Again, once I post a press release up on the web, on, say, my law firm website, you have to kind of treat it the same way you treat any other copy. Attorney quits Georgia Bar's facade committee on client solicitation. This is an issue that comes into play in a number of states. In this case, a Georgia attorney resigned as head of the state bar's committee on attorney-client solicitation because basically he was pissed off that they didn't really do much, right? Like that's sort of the underlying aspect of it. And so that comes to the point of, does your state care? And I do use this as sort of an evaluator in risk assessment in certain advertising. It's very frustrating for a lot of lawyers when they're in certain states where they kind of know that they're following the rules and nobody else is. And there's no enforcement, or there's no enforcement mechanism. And this has come into play in a number of places, and it's always kind of problematic, and it's always disconcerting, but there are states that care heavily about what you do or don't do. And then there are other states where they don't. And that is sort of something that I do take a look at from time to time. The next one up there says Boston firm says personal injury rival stole secret sauce. And that deals with a PI firm that feels like somebody who used to work for them copied and repeatedly used their digital operating playbook and other materials. So there's that concept of competition and concept of, sort of owning your formula, owning your rights. That kind of comes into that IP area again. Attorney loses pro hoc vice status in North Carolina for habitual practice. I put that in there because basically, if you can't market into a state basically saying, like, as your defense, if you don't have a license there, that you were just going to go pro hoc. All right. Like, you can't market based on the concept of, well, if I get a matter, I'll then go pro hoc. Like, you have to already have either a license there or co-counsel there in order to not potentially violate those marketing rules. So that's something that you want to keep in mind. I skipped over Texas modernized barratry ban to include online outreach. And this is interesting because, again, this lends itself to sort of changes in the way that we market. So Texas has passed a bill updating its penal code to expand the definition of illegal barratry to cover new media, as they call it, amid a reported rise in digital solicitation. And so by new media, they say to cover not just solicitation that occurs in person or by phone, but also through a direct message on a social media platform, by another electronic communication, anything that we could consider false, misleading, or a deceptive communication. So it's changes in the way that that states look at the way that you reach out to potential clients, going back to that concept of solicitation. Interesting one in Pennsylvania, where I'm licensed and where I almost live. I'm across the bridge in New Jersey, but a marketer asks a judge to rethink the text solicitation ban in Pennsylvania. And so in Pennsylvania, Pennsylvania's statewide ban on the use of text messages to solicit potential legal clients. And so this is an area where the Pennsylvania interpretation of real-time communication and the appropriateness of text messages is different than some other places. And then a Texas firm says recording shows call center deception. I've had some companies come to me sometimes to look at the way that their call centers function or operate. Because sometimes they say things they're not supposed to say in representing you in a call center. And so they need to, their rule violation becomes your rule violation. It's something to always keep in mind, making sure that they're not giving legal advice and monitoring the way a call center operates or functions. And I wanted to go back to my reference to legal litigation funding earlier, and the fact that sometimes that one litigation funder got in trouble for some ads dealing with hurricanes in Louisiana, again, because they were found to be in violation of the marketing rules, ethics rules. And so you want to be careful that they're following the rules or not really influencing what you are or aren't doing. So who might take issue with your marketing? So when I first started doing this, really, I almost exclusively was kind of focused on, let's make sure we don't violate those 7.1 or 7.2. Let's make sure we don't get a letter from the state bar for one of those types of violations. But really, in real life, in reality, that's not where a lot of the issues end up really stemming from in terms of somebody looking at your marketing. Now, you would think, or you would hope, or you would expect that the main reason that these rules are in place is to protect the consumer. But it is extremely, extremely rare, almost never, that a consumer files a complaint dealing with a lawyer's advertising, right? It almost never comes into play. So when does it come into play? You have the state bar disciplinary arm, which again, was what I was talking about. And I put in there proactive because as I just talked about with certain states that care and certain states that don't, there's certain states that are very proactive in the way they look at a lawyer's advertising and monitor it and do send you letters from time to time. And so that's one aspect. Responding to an attorney complaint, that's probably the one of the most used, which is a competitor complaining about the way that you're marketing or advertising and is claiming or suggesting that you're violating the rules. um, Defense counsel and in-house counsel, and again, another area where I'd say 10 years ago I never considered that as being someone who would take issue with a lawyer's marketing. But now, a lot of times, an in-house counsel on a matter or a defense counsel representing a corporation will basically take a really good look at a law firm's initial marketing or advertising or solicitation of a client to see if they were following the ethics rules when they signed them up, when they started that communication with them. And so that's and so, they might come back and sit there and say, like, and in discovery, they might ask to see the original ads, the original correspondence. Most state bars require you to keep all of that advertising for a certain number of years, anywhere from 0 to 5. And so there's an expectation that you have a record of those ads, where they ran, when they ran, and you would be able to present those if required in the discovery process. The other thing that they look at is, again, whether or not did you submit those ads for approval in the states where they need to be approved? Do they violate any of the rules? Defense counsel is becoming more and more aggressive in looking at the way that you marketed. And that's one of the first areas of attack or of defense that they utilize. Consumer watchdog groups, another area that, why does it concern me? It concerns me because they're consumer watchdog groups. They create bad publicity for lawyers, and so they'll often they might contact a law firm about ads that they don't like. They consider to be deceptive and misleading, and so they can cause a lot of trouble for folks. And so when you come back to who's going to enforce this stuff, the state bars, the courts. I just used that California example. Sometimes it's the state legislature or the governor. Consumer protection laws can come into play, and then external forces that we'll talk a little bit about, like the Better Business Bureau or Google, who might punish you for something that they don't like. So marketing ethics compliance, what are things, I talk about those print ads, and I talk about billboards, and I talk about digital marketing, but what are the other tools that come into play? Social media, obviously, right? I could do an entire hour program, maybe I will, on just social media marketing ethics. But, like looking at the use of TikTok or Instagram or Facebook or LinkedIn in terms of the way that you market yourself, and looking at those social media ads and making sure that they comply. I've often debated with a couple of people as to, whether or not a news conference is could be considered advertising or marketing. I sometimes suggest that they are, but that can come into play when you go to a place where an accident has occurred and you hang out there and you hold a news conference there. Like, a lot of times, again, aren't you there marketing yourself? Are you there in a capacity that's really relevant? The use of newsletters and client alerts, that comes into play a lot with folks. So with like a newsletter, I talk about those solicitation exceptions to clients and past clients. I don't want to have to put in a newsletter or client alert. I don't want to put attorney advertising in the subject line. I don't really want to put attorney advertising in it at all if it's a client alert and it deals with substantive matters. So you want to be careful about the difference between a newsletter and a client alert that's quote unquote marketing and one that's really more informational or educational. A tweet, a blog post, participation in a listserv, participation on Reddit, which I guess is kind of a listserv, text messaging. These are all those areas that, that sort of blur in regard to in some of the rules and some of the regulations. So a blog post, for example, a blog post is typically going to be treated the same way that any other page of your website might be treated in terms of content. Listservs are kind of tricky. A lot of times lawyers participate in listservs where they talk about various things where they're really not thinking that they're thinking that they're in a closed private community. And so sometimes you are and sometimes you're not. But you need to be very careful as to what you say in those communities. So as an example, like I look at the Association of Professional Responsibility Lawyers listserv every day. People don't typically, sometimes they do, they don't typically reveal uh, privileged client information. They ask questions that are more hypothetical in nature, but you need to be very careful about what you disclose. And you can't just sit there and assume that just because you're within a closed listserv that you're in a private sort of protected space. Same thing goes with, things like Reddit. Lawyers have to be very careful as to what they do on Reddit. When they're involved in a matter and they go to a message board that's tied to that matter, and they start talking about things that maybe they shouldn't talk about. That could involve both improper solicitation. You can also involve, disclosing things that you're not supposed to disclose. So it becomes kind of tricky in terms of compliance. And then, an organic Google search result. An organic Google search result to me is not advertising, right? It's not marketing. But those sponsored pages and some of the things that are sometimes put up there, keyword purchases, those sometimes cross different types of lines. And we talked a little bit before about a press release, whether or not a press release is or isn't marketing or an advertising. And again, there are times where it clearly is advertising. If I send a press release to my local rag where I know that they're just going to cut and paste the content into into that newspaper, into that publication, that then often can fall under the guise of advertising, as opposed to me sending something to a journalist or sending something to an entity that will then evaluate it and use pieces of it, but incorporate editing, which then moves it kind of outside the scope of advertising. And then IP issues I talked about a little bit before. Use of logos and slogans and taglines of defendant companies and some of the advertising. I've seen some companies kind of push back on attorneys and say, like, hey, you can't use our logo in your advertising for clients for a class action against us. Okay, so you have to be very careful about that type of IP issue. The other issue that's come up is, the copying of a competitor's website or content or social media. I talked a little bit about that, stealing your secret sauce. This is a little bit different in that you're basically copying, I've had issues where some firms are copying a competitor's website and content and social media posts. I had an issue this past year. I wish they'd let me use them as an example, but they won't. But a firm had actually cut and pasted another firm's content to the point where they didn't even edit out the location of the original firm. And their location was different. It was like a clean cut and paste. Their IP lawyer actually responded trying to blame it on, WordPress templates. It was basically bogus, and they were basically stealing content, and they had lead generation issues in terms of things that were deceptive and misleading. But being very careful or having IP issues come up dealing with copying your website, your content, your social media. So I often advise people, I'm not an IP lawyer. I go to one myself when I need one. But make sure that the content on your website and in some of your marketing is protected through the appropriate IP filings. I've often talked about the Morgan & Morgan effect, which again, especially if you're a plaintiff's attorney, but they've kind of spread out a little bit in terms of their practices. And the effect that Morgan & Morgan has, they're obviously the biggest advertisers in U.S. law, right, in the legal profession. And so they've changed the way that a lot of people have done their marketing. I was speaking recently with a couple of PI lawyers who told me that the cost of doing business in their markets had as much as tripled since Morgan & Morgan came in order to, stay competitive in a space. And so, I've gotten to know some of the Morgan & Morgan guys. A couple of them are my friends. They're great people. But they have changed sort of the way that a lot of lawyers have to market themselves in various communities, and they're constantly involved in spats. Usually they're in the right, to be honest with you, in my opinion. They had one they've had one ongoing dealing with another firm, Morgan Law, creating buying the Morgan & Morgan keywords, which they considered, sort of a deceptive and misleading practice. So that's a recent spat. And then there was recently a case that was dropped in Arkansas, dealing with an Arkansas lawyer who basically said that they had, that their use of client testimonials and some of their advertising had been deceptive, and claiming that it basically had siphoned off business for him. He recently dropped that suit, or that suit was recently dropped. But that was one of those rare cases where I saw a Morgan & Morgan ad where it did technically violate the rules in regard to client testimonials. But whether or not that translated to an individual law firm's lost business, it was obviously highly questionable. If you're interested in, there's a great article on a website in Richmond, Virginia. Like, Morgan & Morgan just moved into the Richmond, Virginia market. If you go to the richmonder.org, there's a publication there. There's a great article about sort of the history of Morgan & Morgan, and sort of it hits some of the ethics issues and some of the sort of the competition issues in those places. But they just hired a new chief marketing officer from Geico. So we know Geico does irreverent advertising. They're also probably one of the absolute biggest advertisers in the U.S. market. And so I thought it was interesting because in a Law 360 Q&A with the new CMO, they asked him about the ethics rules, and he said, I come from auto insurance, and auto insurance has very hefty rules themselves. So it's kind of the same. And I read it and I'm thinking, like, no, it's not the same. And so I'm sure people there will keep him aware of the importance of those nuances. When I look at a Morgan & Morgan ad, from where I live, if I look at a billboard on the Jersey side where I live, and then I cross the bridge into Philly, and there's another billboard on the Philly side, and then I go a little bit further into Delaware, and there's a third billboard. All three of those billboards have different types of disclaimer language that mirror the needs of that particular state. So again, even though people like to think that these things are consistent across the board, they're really not. Lead generators are a huge player in today's law marketing world, right? And so lead generators, are you allowed to pay for leads, right? And so you can pay for leads. You can't pay for client referrals. And we look at different ways that is a lead really a disguised referral. And so you have to look at how the lead is generated, what the messaging was, and how you're paying for that lead. For example, you obviously can't pay a lead generator a percentage of the revenue generated from a case or a client, right? Like, you can't pay. You have to pay for the lead as if you're paying for a component of advertising. So what do states look at? They're going to look at the amount of money that you paid for that lead and see whether or not you're paying for a lead and not for a client retention. So you can't pay based on, I can't get an X number of dollars based on a successful client interaction. It's really got to be based on just sort of straight lead generation. And I often look as a non-law firm company providing legal service. I talked a little bit earlier about call centers. And so sometimes those call centers are prior to the lead being sent over to the lawyer. You have to make sure that they're not in violation, and that there's no impermissible fee sharing. Because in reality, again, like, if you buy let's call it a quote unquote bad lead, or you get into an arrangement that's improper, at the end of the day, the only person who's really going to get in trouble is you, not the lead generation company. They're not lawyers. They're not members of the bar. There's really no way to discipline them. So you want to think about things along those lines when you're involved in lead generation. So state by state interpretation, they're all over the map. I mentioned that I licensed in PA, but I actually live in New Jersey. And New Jersey is a pretty aggressive state when it comes to lawyer advertising. I've seen a lot of law firms get those letters from the state for certain types of ad violations. So in this case, here's a person that got reprimanded because they used the slogan "lowest fees in the state" without being able to necessarily justify that. Just in that case, there's a in the matter of Christopher Fritz, they found that he was reprimanded for false and misleading advertising, using disapproved ads, improper solicitation, improper use of the term specialist, improper use of firm name on letterhead. And so there are all these things that come into play where, again, if, I don't know whether the state identified him themselves or whether a competitor or another lawyer, sort of turned him in. But there are states that really look at all these various concepts of the rules and the way that different states want to interpret the rules. New York State Bar opinion from 2023 looks at a YouTube channel, whether or not it constitutes advertising, and saying sometimes it does and sometimes it doesn't. And one of my favorites for all the wrong reasons is from Kansas, the Kansas Supreme Court in Ray Morton from December 2023. This attorney used, I'll give you examples, used materials from another lawyer's website on her website. She posted logos from bar associations that she didn't belong to. She included a Martingale Hubble AV rating logo that she didn't have or hadn't received. She made several statements about her quote unquote experience, even though she had never practiced in those areas. And despite all of that, the hearing panel found that she was not in violation of anything, really. So, so again, like every state is a little different in the way that they care or don't care to sort of interpret those things. Again, like state by state interpretation, this person received a 3-month suspension violation of advertising, solicitation, misrepresentation, and supervision rules. All these things that can come into play in terms of practice. So one of my favorites is, rate. I do an entire hour on ratings, rankings, and reviews. And so, there are ratings and rankings that are more credible than others. Okay. So if you're in big law, you probably care the most about your Chambers USA rankings, which are considered pretty legit. Right. And if you're at mid-sized firms, you might care more about best law firms and the best law firm rankings. And then there's all the others, which vary in terms of their viability and their credibility. You always have to remember that a lot of those sites, especially the more credible ones like best law firms or best lawyers, they have various terms of use about how you can or can't use those designations in your advertising and your marketing. I still see ads all the time, or get email solicitations or marketing from firms that that refer to themselves as super lawyers, and it's made very clear you can't call yourself a super lawyer. You can say that you're on a list called super lawyers, and usually in some states they'll say like you need to have a link to the methodology used. And so, looking at the credibility of the entity. And so those all come into play. Back in New Jersey, again, New Jersey can't, for whatever reason, New Jersey's always had a thing about ratings and rankings. Like they've gone back to the well a bunch of times in regard to, at one point years ago, trying to basically outlaw their use completely. And they failed there. Because all the other entities got together and spent good money pushing back. But they make it clear in New Jersey, there's the concept of whether or not a ranking is verified, whether, what went into its credibility or legitimacy. I mentioned the use of methodology. And, a lot of times when I'm using one of those rankings, like we make sure we have a link to that company's methodology. What was the methodology behind behind their use. And then say, again, in New Jersey, additional language, specific language that's necessary when you're using these ratings and rankings in your advertising. And so again, some states vary in terms of the way that they interpret the use of those badges, the use of that information, for example, on billboards. And then there's the use of, for example, there's the use of chambers quotes, which large law firms love to use in their marketing. Okay, so there's terms that I couldn't say it about myself, but I can put it in quotes and say Chambers said it about me. And so that makes it credible versus me saying it myself, which could be a violation in terms of the way that the language is interpreted. But the concept of ratings and rankings is still a big one, and one that you still want to pay attention to. I talked a little bit earlier about the use of internet search engine keywords. Again, New Jersey. I mean, it just happens to be New Jersey loves to play in this space. And so this is New Jersey Opinion 735, where the New Jersey Supreme Court was very skeptical about forbidding one law firm from buying another law firm's name as a keyword. These keyword fights in various states they've literally been going on for at least 25 years, where one firm buys the other firm's keyword. And so the way that, the fights are always very interesting. The question is whether or not in making that purchase, you created a situation that was deceptive and misleading, right? Did you create a situation in which it was deceptive and misleading? Did you purchase a keyword for a website redirect? And so again, for the most part, can I buy another law firm's name? Can I basically say, hey, when someone's looking for the law offices of Micah, can I put up, can I buy that? Can I buy that keyword? Can I buy that so that I show up on the search result? And the answer typically is yes, as long as, again, it's not deceptive and misleading. I'm not siphoning off traffic, but I'm putting myself out there when you see me. The concept or the area of online reviews has become, more and more significant in this area. And so it's become so significant because for a lot of law firms, especially on the plaintiff side or the consumer facing side, reviews are critical. Okay. They're not just critical because people look at what your rating is and read the reviews, but they're also critical because the number of reviews can sometimes push you up in search results and in visibility. And so law firms put a lot of time and money and effort into Google reviews and into various review processes. There are a lot of products out there. I like to use this example on the board. This is from Podium, which is one of those review sort of mechanisms that's out there in the practice area. But I like this example. This is the Grand Canyon, which someone gave a 1-star review to, and said, they expected better. And so it's always a reminder that there's no avoiding sort of those crackpot clients and reviews. But the concept of online reviews is really critical, and also how you respond to them. And just recently, there have been some situations in which a number of lawyers or just businesses in general are getting hit by folks that purposely post negative reviews and 1-star reviews, and then basically hold your ranking hostage. And so there was a matter in just last weekend. There's a lawyer in California that contacted Google because there were 68 fake reviews for his criminal defense and DUI practice. And these reviews, were traced back, in that case, I think, to the United Arab Emirates. There's another one I looked at that was traced back to Pakistan. But these people were basically posting negative reviews, and they've done this in all these businesses. They do it to restaurants. And so it becomes a real hardship for law firms and for every other business to get those reviews taken down because they're obviously extremely harmful. So that's one aspect that, that we all have to kind of worry ourselves about now in terms of sort of defending our online reputation. But the other area comes into, how do you respond to negative reviews and how do you make sure you stay out of trouble? So responding to an online review, this is an area where lawyers continually get into trouble. Recently, there was an attorney in Colorado who, in response to a negative review from a client on Facebook, questioned that client's mothering skills and got in trouble for that. You have to be very careful about violating 1.6 and making sure that if you're responding to a negative review or problematic review, that you are not revealing confidential information. And even in some cases, revealing information that you might argue is a public record. You just can't get into those like little pissing matches, right? Those wars. And so you need to be careful about, how you position yourself and how you respond. There's some ethics opinions that are out there. There are attorneys that have gotten in trouble for the way that they've responded. Recently, another interesting area is whether or not you can compensate a client to do a review. And so I've had situations where I've done I've received a text from a law firm, that I've utilized, and it'll say, "We'd love if you could click on here, here, and here, and give us reviews on Yelp and on Google and maybe Avo." And it's time consuming, right? I don't necessarily want to take the time to do it. So can you pay for a client review? And in a recent New York State Bar Association opinion 1286 from September, they remind you that you can give a nominal gift. There was an earlier ethics opinion in which someone asked, "Can I give $50 to each person that does a review?" And the answer was, again, it was yes, as long as you're not drafting it or you're not influencing it or you're only giving it based on, if you give me 5 stars, I'll give you $50. And so all these things that come into play are very important in terms of how you position yourself and how you respond. I always tell people take the TripAdvisor route. If you ever read a review for like a hotel or restaurant you went to, and the review just shreds you, and then you see the message from the general manager saying, "We're sorry that you didn't enjoy your experience. Be sure to let me know, next time you're here." Right. And so, obviously you're not going to be there again, but they don't sit there and try to respond to the individual arguments. So you want to be very careful how you respond to an online review. Going back to, when I talked about, sort of marketing 101 at the beginning, 7.1, 7.2, disclaimers, etc. There's being careful still about the use of terminology like specialist and expertise and leader in the field, father of healthcare law, whatever it is that you say. And so every state's a little bit different in the way that they allow components of specialization to be used. If I specialize in something, most of the times the use of specialization or expertise when I see it in a law firm ad or on a website is improper. I always kind of shudder a little bit. But what you want to make sure is that, if you are using those terms or using some of those logos of specialists, that they're permitted where you live. And so you want to be very careful about the use of specialization and those types of terminology. So one of the when I talk about states that care and states that don't care about the way they market, these are two states that always care or seem to always care: Louisiana and Florida. And so whenever I get an ad campaign and I see the words Florida, Louisiana, and I'm always like, oh, those are both states that require pre-approval or approval of ads through the submission process. They have these, if you go online to either of these state bars, they have these handbooks that go through all of the things, all the subject matter that I've gone through this past hour. and talk about, what you can and can't do. And they interpret things again, different states interpret things differently as it relates to advertising. Florida has all these nuanced rules as it relates to things like, again, what they consider to be a targeted ad, what they consider to be something targeted directly to a person, is their interpretation is different, I can tell you, than my interpretation. And so you need to be very careful when you're kind of playing in those spaces. I usually, if you're going into Florida, I usually have Florida counsel that is submitting the ads and vetting everything that needs to be vetted. Louisiana has a very interesting database that you can access. So where you can basically access all of the advertisements that have been submitted, which again, as a marketer at heart, I don't like the idea that a competitor can basically go look at all of my advertising through the Louisiana Bar database, but you can basically go and look and see what people have submitted and what's been approved and what's not approved, and use that as sort of a guide to what you can and can't do. But that those two states, and then there's still other states that have, sort of that pre-approval process or that approval process of advertising that requires a form to be submitted. It requires a check, and it requires a number of different things. Nevada is still one of those states. Connecticut is one of those states. And so, you want to be very careful of states in which there is that approval process. And it becomes really tricky in certain areas of practice because, it can take as long as, it doesn't really take as long as a month to get an ad approved in Florida, right? Because first of all, you do have to do it by USP. You have to do it by mail, right? You can't electronically send it in. So you're creating it, you're sending it in by mail. Inevitably, most ads are rejected for something that you then have to fix. Okay, so now you're 2 weeks in, and now you fix it, and now you're another 2 weeks in, and now it's a month later. Many of these ad campaigns, especially in relation to areas of things like class action, mass torts, various aspects in which time is of the essence. You really can't wait a month to be able to start advertising. And so there are times where I sometimes pull people out of various states and say, like, let's not advertise or let's not market in those places. But those are all things that are considerations. There are a lot of people that think that you can just put some little disclaimer. I see them every day in my Facebook feed, like these ads that you're not it'll deal with a particular location. Let's say it deals with Maryland. And I'll look at the law firm that's doing the advertising, and there's no one there from Maryland. There's no law firm there from Maryland. There are no Maryland licenses. And they'll have that little line, use local counsel, when necessary or when needed or if appropriate. And again, that's not really a catch-all. That's not an end around that's appropriate. You want to make sure you're licensed in the states in which you're marketing. So AI, who doesn't talk about AI? It's like, it's so ingrained in our lives now. And so, how does AI come into play in regard to the way, and we kind of know because we read about it every day in regards to the way that lawyers are using AI and getting in trouble for case hallucinations and improper cites. And those are all, dealing with the practice of law. And it's interesting to see how different courts are interpreting those. The New York State Bar, when they did their original AI report on tie-ins to their rules of professional conduct, they pointed at 16 different RPCs that were relevant to the use of AI in the law firm setting. But how does it really play with law firms and law firm marketing, right? And so, there's the use of chatbots and the use of chat, which might be AI driven. And again, making sure that the AI isn't saying something that you're not allowed to say. AI, I still don't think that AI knows the specific rules of professional conduct and what you can and can't say and what you can and can't do. But it's come into play for me. And again, like an AI generating copy for your press release or your news item or your website may not understand the specific use of terminology like, expertise and specialization. And often there are times where AI is grabbing content that is often quite duplicative of other folks' websites. So it comes into play with website copy, in which AI is violating the rules of professional conduct. You don't understand it or you don't see it, but it comes into play. And so those are all important things to keep in mind when you're using AI to generate website or just marketing content in general, making sure that if that the AI content that it generates follows the rules of professional conduct. Because a lot of times we're using ChatGPT, or we're using Copilot, and so we want to be careful as to what data we put in there, what data we pull out, and making sure that we don't violate the rules inadvertently. So, in terms of all these advertising considerations that we've talked about, what are some of the things that we want to think about or we want to keep in mind, thinking back to the last hour of time? One is the record retention policies. Just again, a reminder that every state's a little bit different in terms of both the number of years and sometimes their interpretation of what retention looks like or means. But if I come back to you, let's say I'm defense counsel and I go back and I'm pointing at an ad that you created, 2.5 years ago, and I'll say, like, I want to see that ad and where did it run and when did it run? In most states, you're expected to be able to provide that. You should be able to say to me, like, that was an ad campaign that we ran on Facebook on November 23rd, a year and a half ago, to people in Illinois, right? And so, record retention policies are important in terms of keeping track of what you do from a marketing standpoint. That also lends itself or leads itself into the concept of oversight responsibilities, right? And so you can't blame the litigation funder. You can't blame your marketer. You can't blame the search engine optimization company. You can't blame any of those people for violating the rules. At the end of the day, the law firm who is being marketed is the one that's responsible. Same thing, especially within the law firm setting. Be saying that my marketer did it and I wasn't aware, or they didn't do it, they did it without permission. That's not a defense. Specialization expertise I talked about that concept of referrals versus paying for the reasonable cost of advertising, right? Like, I can't pay for a referral, but I can pay for a reasonable cost of advertising. Make sure you're aware of the disclaimer specifics in your state as to what you need to put up there on your website, in your social media, various components, various sentences that are specific to certain states. I mentioned testimonials. I mentioned that Arkansas lawsuit with Morgan & Morgan. Again, like, some states still have various requirements that tie to things like the use of testimonials still. Not a lot, but there's still some. And then obviously ad filing requirements that I just talked about, whether you're in a pre-approval state, whether there's an expectation that ad's been sent in. I can tell you, like, it's always hard for me because, I'll look at ads where I'll say, like, we have to submit this for approval, and then I'll know that nobody else is, right? Like, I'll see all these competitors out there in that space that are running wild for weeks while we're going through that process. So you have to kind of do a risk assessment, and sometimes you have to play a little bit with your marketing to make sure that you increase the odds of compliance.
Wonderful, Micah. Thank you so much. Before we move on to some questions, if you have a few moments, and we can now move on to questions. So if you have a question for Micah that you'd like to ask, you can always submit it through the Q&A button. It looks like we've got a couple. We'll go through those and then wrap up today. Our first question is, how can attorneys determine which state's rules of professional conduct apply when their marketing can reach audiences in multiple jurisdictions?
So that's a great question, and obviously that's something that I look at in every campaign every day. So that's one of the first things I look at is, what states are relevant for that advertising. And so, like, if just because I can see your website in North Dakota doesn't mean that I have to abide by the rules in North Dakota, right? Like, that's not how it works. Even though I once had a disciplinary counsel suggest that if you could see my site in Connecticut, then you have to abide by Connecticut, but that's not true. So what you really look at is, it's usually more likely to be what is the messaging and what are you targeting? So if you sit there and you have a page that says, birth injuries in South Carolina, you're clearly basically now saying that, you're looking for matters in South Carolina. So I'm usually looking to see, where is the matter potentially taking place? So do I need to be licensed? If there's an accident where, a building collapses in Maine, and so I have text, I'm marketing for clients in Maine. In that case, like I have to look at Maine, I have to look at the rules there, I have to look for a license there. In many of the campaigns I look at, one of the first things I do is I go to my law firm client, I look to see whether they have a licensed attorney there, whether they have an office there, whether we need co-counsel there. So those all come into play. But, just because I see it doesn't mean that I have to comply there. But at the same time, especially when you're doing targeted ads, most of my campaigns are running on Facebook, they're running on Instagram. And so one of the first questions I ask is, where are those ads running? Like what states are they running in? Is it a national campaign or is it an individual state? And if it's an individual state, I'm usually looking to comply in that state.
Thank you for that insight, Micah. Our last question for today is, what lessons from cases like Bates versus the State Bar of Arizona and other ethics decisions related to advertising do you feel have remained the most relevant as we move into a digital heavy kind of marketing strategy?
Well, I think the biggest struggle that states have had is that, the original rules of professional conduct that you looked at, especially as they tied to advertising, became so outdated. So once you hit sort of the digital age, once we got into sort of the internet world in the 90s, most of the rules, just didn't come, they didn't cross over, right? They didn't work. They were built for a directory. They were built for a billboard. And so, so the hardest thing really is making sure that you're keeping abreast of changes. Like I used a couple of examples that dealt with text, right? Like nobody thought about text messaging. People weren't thinking about Reddit Reddit pages on a particular topic and how that would or wouldn't become sort of advertising or marketing. I didn't use it as an example today, but a lot of times I'll say, like, in California would have had a specific sort of interpretation or rule that basically if in content it said you basically said I'm available for employment, or you retain me, or I'm here to be hired. Now that content, whether it's a blog post or an article or anything else, becomes advertising, as opposed to sometimes just saying, like, here's an article I wrote, and taking out language that necessarily created sort of that solicitation aspect. But that's again, like, it's the fun part for me is that the space changes so much and so quickly. Like, none of us took litigation funding into account, when we looked at the way some of these rules are interpreted. And so all these things come into play now. And then those changes from state to state, like we talked about states where, like, there's the alternative business structures. A lot of law firms like to set up in Arizona now to take advantage of ABS rules. Or a lot of firms that like to go into DC to take advantage of fee sharing with non-lawyers. And so when you're in those places, but then you cross over with a licensed attorney in another state, now you create the sort of that fuzzy area that needs to be interpreted. But there's the other thing about it too is that a lot of this stuff ends up being so subjective that what one person sees as a violation, another person doesn't. I'll quickly mention, in Florida, I think there are 8 or 10 lawyers that review ads. I would suggest that some of those lawyers see things differently than the person sitting next to them. And so sometimes subjectivity comes into play, and that's obviously always hard to interpret or plan for.
Done. Well, thank you so much, Micah, for sharing those additional insights, answering our audience questions, and for your presentation today. We want to thank you so much for joining us for another Justia webinar. Before you go, don't forget today's webinar is part of our 5-day sprint of ethics programming, and your Pro membership does afford you more than just that CLE credit. You also get an enhanced directory profile with a Pro badge, removal of competitor ads, access to our AI-powered Justia chat to help you boost those leads, and $200 off of select Justia marketing solutions. So you can learn more today if you want to upgrade, or just check it out at pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.